1852.
All right. The record should reflect I've had a chance to talk briefly with the attorneys in the back on the issue of the witness that has been the subject of some argument on the record so far today. And I believe they may have some comments to share that will resolve that issue. Would you like to begin, Mr. Flynn?
Yes, it's my understanding at this time. Well, let me just quickly give background. Judge, the only reason I brought in a rebuttal witness was because on the last day, Friday, before the hearing was to start, or Tuesday, whatever it was, before the hearing was to start, we received reports from our colleagues that, in essence, objected to agreeing with the declaration of death. It is my understanding, speaking to Mr. McFarland, he is satisfied that by clear and convincing standard from the testimony that's taken place, that in this court, that he is withdrawing that report, but he's going to need a few minutes to lay out his report. But with that agreement, I'm not calling the rebuttal witness to his report. Again, I also understand counsel is going to also opine that lays out the factors, Ms. Wilhelm, that lays out the factors of death. And I don't want to speak for her, but after laying out those factors of death that have been established by the experts and others in this case, she is satisfied as well, but she leaves that decision to this able court, and your decision she's going to abide by. But I don't want to speak for either one of those two, but that's my understanding. Therefore, I'm withdrawing. It's also my opinion, but I will address after this witness the motion to strike.
All right. Would you like to respond, or would you like me to confirm with our other counsel as to the representations made by Mr. Flood?
I'm in agreement with what Mr. Flood has said. I was in the back and I listened to everybody, and they confirmed the position that he just put on the record. If the court would like to talk to each of them, that would be fine.
All right. If we could have you to the podium, please, Mr. McClellan and Ms. Wilhelm. And Ms. Berger will go to you.
Your Honor, a point of clarification. As an attorney guardian ad litem for Deanne Warner, I submitted a report, as I'm required to do, and this is prior to the trial, prior to the testimony. So I'm not withdrawing the report, but I will be giving a verbal report and recommendation in which I do believe that the burden has been met and that she is deceased. In fact, I'm going to say that I believe she's murdered. It's going to be my conclusion on this, Your Honor.
And Your Honor, no. For a point of clarification, it was never an objection, always just a PC 643 outlining ideas. And I think that Mr. Flood very fairly represented my position. And I do want the law to be followed, and I do respect your ability to do that. So I would be leaving the ultimate decision to you.
Thank you, Ms. Wilhelm. Any comments on our sidebar, Ms. Berger?
I have nothing additional to add, Your Honor.
All right, Mr. Polerman, we did miss you during that, but we had Mr. Bullock available to us as we walked through this in the back. And effectively, as I understand it, the witness will be released and will not be called this afternoon, which would resolve as well the motion to strike.
Yes, Your Honor, but I would also like her report, which was submitted in anticipation of her testimony, stricken as well.
What does that mean? Judge, it's not into evidence right now. It's not stricken. I filed it with my motion. It's a public document in this court, so I can't strike it. It's not admitted right now into evidence. So how do we strike something not in evidence right now?
But it was added as an exhibit, and I would like the exhibit stricken because it is a public document, and in order for my client to be fairly represented and have a fair hearing, I think that puts the cart before the horse. It's a detailed report that calls for a diagnosis, clearly there can't be one.
Oh, well, as I visited with all of you in the back, this was a motion filed and it was not filed in time to be heard today. So the issue of whether or not this person will be a witness today, I think it's been resolved.
Yes.
If you wish to continue to pursue your motion to strike, you're welcome to do that and let the clerk's office know that you would like to have a hearing date for that particular issue.
Right.
All right, anything, Mr. Folderman?
No, Your Honor.
Thank you. Well, Ms. Raquel, you remain under oath.
Yes.
Ms. McBrown, you had some questions?
Just a few. Again, I'm sorry in your position today. I do have a few questions. You had said that Dale was in daily fights with your mother. What do you mean by fights? What do you mean by daily? Just so I have an understanding of what you were saying.
They fought about either the business or money or honestly anything.
Well, is fighting arguments? Is fighting physical touching? What does that consist of?
Arguments.
Okay, thank you. You had also said something I wanted to get clarification, something that Dale was supposed to be doing something with Angelina that he wasn't on the day that your mother, on 4/24. Do you happen to recall what you were talking about when you said that?
I don't recall.
Okay, that's fine. That's fine. I know you said that your mom had feared that she was going to be on Dateline, but as a matter of fact, she has now been on Dateline on the internet, right?
That is correct.
I guess just lastly, I don't think we've ever made a record of how old your mother is. What age was she when she went missing?
53.
She'd been 51?
No,
53? Okay, thank you.
2.
52? Thank you for that clarification. And how many years had she been married to Dale Warner?
I believe since 2008.
Okay, I'm not good with birthdays, so I can
Not sure.
understand that. Okay, or anniversaries. Craig Miller. I don't think that's been established. Is he a marriage counselor?
I believe he was their marriage counselor.
Thank you. Okay, I'm sure about that. And last question. You indicated your mom was crying and upset the last day you were with her. I didn't quite understand why it was she was crying and upset. Have you already covered that, do you believe?
I mean, I can clarify for you. If you'd
Okay.
like. They were fighting about the businesses, and some things got out of hand with an employee, and she felt like Dale didn't have her back, and that was what their fight was about, I believe.
Okay, okay, thank you. That clarifies that. I appreciate it. Nothing further. Thank you.
Ms. Wilhelm?
No questions, Your Honor.
Ms. Berger?
Yes, thank you, Your Honor.
Ms. Bach, you testified that your mom suffered from migraines, is that correct?
That's correct.
How bad were these migraines?
She had at least one every week, I would say. Sometimes she would not be able to form a sentence when she had one. She's been hospitalized for them.
Pretty debilitating.
Yes.
And had you ever known her to go without her medications for those?
No.
And were they, if you know, were they like a day-to-day, like a maintenance medication or an emergency medication, as if she could feel a migraine coming on and she could take something to help stop it?
I believe they were both. I believe she had a daily medication to prevent them, and then also she had different strengths of medication for the severity of the migraine.
Okay. And did you ever travel with your mother?
I'm sorry, what?
Did you ever travel with your mother?
I have before, yes.
And when you would travel, would she, if you know, fill these medications beforehand?
I don't know that, to be honest.
Okay, that's fair. And you testified a few times when Mr. Lee was asking you questions regarding not calling Dale on the day you realized your mother was missing.
Mhm.
Do you remember that?
Yes,
And why didn't you call him?
I didn't care to talk.
And you testified that you didn't really get along, is that correct?
Correct.
And why is that?
He just wasn't my favorite person. I tolerated him because it was the husband to my mom and the father to my little sister, but. that was it.
And did he have any meaningful conversation regarding where your mother could be?
No, all he had to say was that my mom had all these pills and she he said that she had a burner phone, and it was actually nothing but negative things to say about my mom.
Was there any worry, if you're
No.
aware? And you mentioned that he had stated something about her wedding ring, is that correct?
Correct.
And he stated that she had left it on his desk, is that right?
Yes,
What desk?
his personal desk in the office.
And is the office in the home or is that separate?
It's separate.
Okay. And about how big is that office?
It's kind of different, like sections. Almost like different rooms.
Sure, okay. And if you walked in the door that you would normally walk in, how far away would that be from, say, your mom's desk?
In another room.
Okay, and what about Dale's desk?
I'm sorry, I thought that's what.
Did Dale have a different desk in that office other than your mom's desk?
Yes, I'm sorry.
And is that in the same room as your mom's?
No.
Okay, what room is that in?
The room next to hers.
Okay, so if you walk in, could you see Dale's desk?
No.
Okay. And when you went there to look for your mom, did you look around in all of the different rooms?
I briefly did, yes.
Okay. And the ring that we now believe to be missing, or we don't know where it is, that was a decently sized diamond, correct?
Yes,
And you had seen it before?
yes.
And do you know how she got that ring?
It was a newer ring because she lost her previous ring.
Okay, so it was like a replacement ring.
Yes,
Okay. And rings are fairly small, right?
rings are, not hers.
Rings in general.
Oh, yes, I'm sorry.
Okay, and even if you had a pretty large rock on it, it could be mixed up in a desk, right?
Oh, absolutely.
Okay, so if I set my ring right here and you walked in the door and looked around for a human person, is that something small enough that you might miss?
Absolutely.
Okay, and can you see my ring right there?
Barely.
Okay, and if it's down here, can you see it?
No.
And was your mom's desk fairly clean or fairly messy?
It was actually at Dale's desk and there were papers, all over its desk, so,
So fairly messy?
yes.
I have no further questions, thank you.
Thank you.
Well, wait. We do have a Zoom participant. Mr. Folderman, do you have any questions?
I do not, Your Honor.
Thank you. All right, back to you, Mr. Flood.
Thank you. Judge, may I use your board?
You may.
Thank you.
I'm not sure if we've got markers in there, but.
I checked it out earlier.
Oh,
We watched it.
okay.
Go ahead, Judge. Kelly, you remember the questions that Mr. Lee asked you about? You have no evidence. Remember that?
Correct.
Remember your answer? You told him you're not a cop.
Correct.
Okay. So, did you say to the court that Dale and your mom were in a toxic relationship?
Yes.
Toxic relationship, is it self-explanatory, right?
Yes.
It's explosive at times,
Yes.
loud at times,
Yes.
and you said on the day you saw your mom, the last day, you said she was scared.
Yes.
Scared of Dale?
Yes.
You said, if I understood it correctly, Dale tells you, I don't want to report her missing until the next day.
Correct.
You don't know because you're not a cop, but evidence can get destroyed if you delay getting it, right?
Yes.
Okay. You do know that.
I'm gonna object. This is all leading.
All right, I'll make it.
Calls for speculation the way it's.
No, Judge.
Okay, wait, let me listen to his objection
All right,
first,
fine, I got
then
one
you can
second.
respond. Your objection is?
Relevance and calls for speculation from somebody who's not law enforcement. She already testified she's a cop. How would she know whether or not there's evidence that's destroyed or something because it's delayed report?
Oh, I'm sorry, I'll withdraw that to common sense. Judge, I'll withdraw the question. That she doesn't know that evidence can get destroyed if it's delayed in being picked up. I'll withdraw that. But he says to you, I want to delay her missing the report, correct?
Correct.
Okay. You said to the court, Mom would never leave Angelina, right?
Correct.
Did you say it was her habit to the judge earlier that she was always with? It was, I think you used the word in quotation marks, inseparable, right?
Yes.
Okay. All right. You said to the court, if I understood it correctly, she had medical issues.
Objection, Your Honor. This is just merely a restating of what the testimony was. There's no question here.
I'm just asking her the question. Did you state, because I think he stated, Your Honor, that she didn't know, she didn't have any evidence that Dale killed him. And
There's no evidence.
I'm just now going back, Your Honor, to say she does, but she may not know the definition of evidence. And I'm asking her these questions because he tried to say she didn't know the definition or didn't have the understanding and she had no evidence that Dale did the murder. So I'm rebutting that.
Dale didn't do the murder, and there is nothing that suggests that he did. So,
Well, I'm just going through it.
All right, I'm gonna overrule the objection to allow the rebuttal, the redirect on this particular issue.
Thank you. I'll be quick, it's to the extent I can, Judge.
Thank you.
You said your mom had medical issues. If I understood you correctly, just please correct me if I'm wrong, that needed attending to on a regular basis.
Correct.
I think you just said that with the migrants, yes?
Yes.
Did you notice in the last 6 months, you saw your mom every single day? Did you notice in that 6-month period that she broke her routines? She changed something up. She was missing and gathering things. Did you ever notice her go off her daily routines that was abnormal to you?
No,
So routines that she followed with you were similar and habitual.
correct.
Mr. Lee tried to, if I understood it correctly, asked you questions. I shouldn't say tried, it's a bad word. Asked you questions about your mom's acumen for running the business. Remember all those questions about running the business?
Yes,
Okay. How about your mom with computers and being able to, you know, do the work on computers and searches and understanding all of the IT world? Was she any good at that?
no,
Okay. So she wouldn't know how to erase things, or did you have to explain to her how to open up apps and do
I'm
things?
gonna object. Her testimony was she was never in the office and she didn't discuss the office with anybody.
Oh, no.
Those are my questions.
I have it
She was
memorized,
there.
Judge. I have it
She
memorized.
said she
Mr.
was
Lee.
never in the office.
I don't think they're talking about office, I think they're talking about technology.
Yeah, I was talking about the questions specifically to, and you remember, Judge, you remember this. He asked those questions about how smart she was and how she ran the business and the finance and then the accounting. Remember all that? I'm asking now these questions about how smart she was with regards to the programs, the accounting software, the updates of HR, you know, those types of things, because it's already been testified to by an expert that he did the research, and now she was remedial with the phone. So I'll just substantiate.
How would she know?
Well, let's ask.
Okay, all right. Objection, response, then I either ask more questions or I make a ruling, right? So let's go back to the basic format here. The question is about whether or not Ms. Bach understood anything about her mother's limitations as it comes to a cell phone. That doesn't really touch anything on the office, but if it goes into the office, I would agree with you. So sustained as it relates to anything that she doesn't have personal knowledge as to, but overruled as it relates to any information she would have on just a lay witness basis of her observations of her mother's phone usage.
Yes, the question is, as it relates to technology. Was your mom savvy in technology?
no,
Okay. You show up to the house on a day, the 25th, right?
Mhm.
Is that a yes?
yes,
And on that day, on the 25th, you know what car your mom drove on a regular basis?
her Cadillac Escalade,
Was that Cadillac in there, in that house?
yes,
You didn't drive it there?
no,
It was already there.
yes,
Are you sure?
yes,
Okay. Any other car you notice?
her Hummer,
Was that there?
yes,
Did you drive that there?
no,
Are you sure?
yes,
Any other modes of transportation?
some of Dale's vehicles and maybe some farm vehicles.
Did you notice anything missing that your mom would normally use for transportation?
I did not.
No. Other than her, in your opinion, being murdered, can you give me any plausible explanation based on what you know that she voluntarily left?
No.
Okay. As you sit here today, we just whipped out 8 quick things of what you noticed in your mom's life. Yes? And no changes in her daily routine behavior that made you suspicious of something, right? Okay, I have no other questions. Thank you.
Recross, Mr. Lee?
This is Steve, Your Honor. Raquel, Mr. Flood led you through this laundry list of what he thinks are important that somehow prove that your mother was murdered. There's been no evidence offered whatsoever that she was murdered, but I have a couple of questions for you. One, while you were looking for your mother on the morning and through the day on April 25th, 2021, did you find any of her personal effects missing?
Yes,
Okay, what did you find missing?
her, at first I saw her curling iron was missing and her makeup bag was missing. But I went back a couple of days later to identify my toothbrush and stuff at their house, and the curling iron was in fact there. Not in its normal spot, but there.
How about the makeup bag that's gone?
Yes,
Were any other personal effects that you could tell missing at the time?
no,
We listed a number of things that your mother was suffering from: migraines, neck and back issues. We had mentioned a couple of other things. Was your mom ever treated for any form of cancer? You know,
You're beyond the scope of redirect.
I'm just, somebody.
I agree on the objection.
Did you want to,
No. I mean, if she knows. Curious if any of those drugs were cancer drugs, you know?
Your Honor, I still have no objection for the chance.
I'll withdraw it.
anyone else have any recross?
Nothing further, Your Honor.
One question. Mr. Flood asked you about, just last time here, about you being over your mom's a lot. Matter of fact, the house that's being built is right across the street from your mother's residence, right?
roughly, yes.
Roughly. Okay.
Mr. Colderman?
Nothing further, Your Honor.
All right, thank you for your testimony. You may return to your seats. Your next witness, Mr. Flood.
Judge, at this time, the petitioner would call Dale Warner to the stand.
All right, well, two things. It's 4:15, and I'm not sure Mr. Warner's with us. Do we have your client, Mr.?
I was told he was here. Just a moment ago, you told us that.
I never said anything.
Oh, in the bag.
I don't know where he is. I don't even know if he's been released from jail yet. I mean, the order went over there hours ago.
Well, perhaps the best use of our time at this juncture would be frankly to look for additional time, unless you're gonna do you have other witnesses other than Dale?
That's my last witness.
Were you gonna have any witnesses?
No, but I can effectively put on the record that he would take the fifth. So if that speeds up Mr. Flood's process.
Well, Your Honor, Mr. Lee made a motion to strike. And in that motion to strike as 801D1, party admission by an agent, right, lawyer, he adhered exactly what his client would say. It did say, he believes. That would be Mr. Warner, believes, and always is believed. So this admission that he's made in these papers, you can't be a little bit pregnant. You can't lose your, keep your Fifth Amendment right when you waive it and use it, back and forth. He waives his Fifth Amendment right by putting that in writing. So, Judge, there's plenty of case law. We use it in the prosecutor's office several occasions when a witness takes the stand and then all of a sudden wants to answer some questions and not others, wants to answer direct but not cross-examination. You can't be a little bit pregnant here, Judge. Once that happens, he loses his Fifth Amendment right.
That is not true. Mr. Flood knows that. He's been doing this a long time. This is not a criminal case, but Mr. Warner has been identified in court this afternoon as a suspect. He will take the Fifth Amendment. He has a right under the U.S. Constitution and the Michigan Constitution to do that. He will not answer any questions.
Well, let's, if I could have you all look, I've had an opening unexpectedly next Tuesday on the 22nd.
Your Honor, I'm not available in the next 2 weeks, for sure.
on the issue of the Fifth Amendment and the issues raised in the motion.
Which motion is he referring to?
I think he's referring to the motion that's not set for today. Am I
The
right?
motion to strike. Mr. Lee had put in writing affirmations of what his client is saying. And under 80D1, obviously party admission, he is saying what his client is testifying to. So I thought, I was always under the impression, and I would accept this if the following was admitted to in the beginning. Mr. Lee would state, as he did in the beginning, that he withdraws his objection to the petition, one, because that basically doesn't withdraw, he then goes back. So withdraws and states that we've met our burden by clear and convincing evidence that Dee Warner's dead, and that his client would take the Fifth. That would end all of this.
That's how it began, and that's what I would state.
Well, that's not what was written.
I'm not sure where.
Yes.
I'm not sure where Mr. Flood's reading that, but my client has an absolute constitutional right to his Fifth Amendment rights under the US Constitution and the Michigan Constitution. Mr. Flood was a prosecutor for over a decade. He's well aware of that.
Mr. Lee, let's just slow down for a second. Hang on, before we jump back into this issue, do any of our other attorneys have witnesses to present?
I have no witnesses, Your Honor, but I would make an oral motion that I believe would resolve the pending motion and answer. If the proposed report by the expert that we did not call today could be placed in the non-public file, it can remain in the court file because that's what happens when we file things. It still has to remain in the court file. It can be redacted to protect identifying information or placed in the private file. And in addition, I do believe, actually I know for a fact that in Mr. Lee's motion to strike, it states that Mr. Warner hopes and believes that his wife is alive. So if that motion would be withdrawn and the proposed report be put in the private file, I think that solves Mr. Lee's concern about that report being out and issued to the public and any potential trials or hearings afterwards. And I believe then it would resolve Mr. Flood's issue of Mr. Warner basically calling take backs.
I have to add on though, Judge. I mean, Mr. Lee unequivocally, his client originally took the Fifth. He then tries to play with forked tongue and say something in this motion to strike. Take that out, one, he takes the Fifth, two, and then he puts back on the record in front of this court. So this court is clear about what his position is that the burden is met that Dee Warner is dead. If that happens, I withdraw. I'm good.
Mr. Polderman, do you intend to call any witnesses?
I did not, Your Honor.
So at this juncture then, we are at the closing of the presentation, I would assume.
I do not either, Your Honor, have any witnesses.
Thank you. So the motion is not set for today, right? So the question is, do you want to resolve it as some of these ideas have suggested by Ms. Berger, or do we
I am
find a different
comfortable.
day? And I send Mr. Flood home with a homework assignment to get me the case law to support his position, indicating that he thinks that your claim is waived? Or do we simply proceed into closings, and then I will probably have to just give you a written opinion so that we don't have to talk about coming back until October?
First of all, my client would take the Fifth Amendment. Second of all, it's his absolute right to
Can you
do
speak
that.
up just a bit for us?
First of all, my client would take the Fifth Amendment. It's his absolute right under the US Constitution and the Michigan Constitution, and he would do that if called to testify. Second of all, he has not waived his Fifth Amendment right by putting something in a document, hoping that his wife is still alive, hoping. We do believe that Mr. Flood may have met his burden. We have not objected to his petition. I said that unequivocally last time and this time. I do agree with Ms. Berger's position that the witness can be struck, but the report can be placed in the non-public file. And therefore, I think that would satisfy the fact that if it were to be used at a later date, it would be available, but wouldn't be out there glaring for the community in a public forum. That's my position. So yes, I do believe that Mr. Flood may have met his burden. I do not object to the petition. Mr. Warner does not object to the petition. We're ready to move forward.
Do you intend to continue to pursue your motion?
I do not.
I just need him to take out that equivocal word.
May, did you hear that? May have met his burden? Take out the equivocal word and make it unequivocal. I understand Mr. Flood has met his burden. That's all. He withdrew his, this shouldn't be a gamesmanship. So that's all I ask.
It's no gamesmanship, Your Honor. It's up to you whether or not Mr. Flood has met his burden.
All
You
right.
don't object to the petition.
You are going to be withdrawing your motion?
Yes.
Mr. Flood, you are willing to agree that the report that was supplied would be placed in the non-public files?
I don't have an issue. I want the court to add it. It's already been filed, so its bell's been rung. But yes, put it in the non-public file. I think that satisfies this judge, but I'm good with that.
Counselors, any objections to those two?
Your Honor, I'm for full transparency on this case. My only concern is once something has been filed and it's public, to take it out of the public view and then stick it into a private file where it can't be viewed. So that's my concern is with public transparency on this.
I understand that.
I understand, because it's already been out.
I mean, in your file, public file.
Your Honor, with all due respect, I believe it's an issue of fairness. And if there is to ever be any other further action in this court, my client would certainly want, as anybody else would want, the opportunity to have a fair trial. And that would be out there so that anybody and anyone could go and read it. And I don't think that would be very good.
I don't have an objection to putting it in the private file, just letting you know it's already been wrong. That's your issue.
I have nothing further to add, Your Honor.
Is Wilhelm any opinions?
No, nothing to add.
Mr. Polerman?
No, Your Honor.
Okay. All right, we have in this particular case before, dealt with the issue of information that shouldn't necessarily be released to the public, bank account records and some of these other pieces that have formally come before the court and that the attorneys have agreed to make essentially confidential. And that was conducted, I think, in accordance with the rules and the statutes that govern those particular issues. I have no problem allowing this report to be, at this point, confidential as far as the official court file. If that resolves this outstanding issue and allows us to get to closings. And everyone's nodding, so.
Just for me, Your Honor.
Yeah, it does for me, Your Honor. I'm just curious about the close. It's already 4:30. We had a lengthy day. We got a lot of exhibits. We got a lot of testimony that's taken place. I want to do it competently for you, Judge, and not shoot from the hip here. I mean, I've done it a gazillion times, but this is a serious matter with serious ramifications on multiple levels. So I'd like to at least indulge the court with, as opposed to the last minute. If you want me to go now, I'd be more than happy to do so. I'm able and capable.
Well, I have some time. If we want to look at September 13th, I believe you're all here already. This was the date and time set to previously review the civil contempt in the event that we needed it. I can offer that time slot to you beginning at 9 or 10 o'clock, understanding that we had that 11 o'clock already set. Counselors?
I'm fine with that.
Thanks for me, Judge. Thank you.
All right.
It's okay.
All right, so we'll set our proceedings to conclude on the 13th of September, beginning at 9 o'clock in the morning for purposes of closing arguments and my ruling.
Thank you, Your Honor.
All other prior orders remain in full force and effect, including the one that releases your client and the other file. And unless there's any questions, that's all for today. Thank you everyone for coming and for your time and testimony and efforts.
Thank you.
Thank you, Your Honor.